Picture this. You just made a massive financial commitment on a brand new car. But instead of enjoying the open road, you're practically on a first-name basis with the dealership's service advisor, right? You're stuck driving some loaner that smells like stale coffee. It is an incredibly frustrating reality for thousands of people every single year.
So here's the big question we really need to answer today in this explainer. Is that annoying rattle, or maybe that stalling engine, just a quirk of your specific vehicle? Or is it legally a lemon? We're going to figure out if your frustrating vehicle actually qualifies for legal protection. And more importantly, how the California lemon law gives you incredible leverage to fight back against these massive auto manufacturers.
Okay, here is our roadmap for today. First, the California lemon law. Second, does your vehicle qualify? Third, the Civil Code explained. Fourth, calculating your lemon refund. And finally, the timeline and process. Let's dive right in. Section 1. The California Lemon Law. Understanding your consumer protection rights. Right at the very foundation of this consumer protection is your main weapon, and it's called the Beverly Consumer Warranty Act. It's been on the books since 1970, and it does something that's actually very simple but absolutely powerful. It literally forces manufacturers to stand behind their written warranties. Basically, if they sell or lease you a car, a truck, an SUV, a motorcycle, or even certain RVs, and it has an unfixable substantial defect, they are legally required to replace it or refund your money.
Sure, but the manufacturer is still legally obligated to repurchase or replace a defective vehicle that they can't fix after a reasonable number of tries. The core protections of the Beverly Act, they remain your ironclad shield.
Moving right along to Section 2. Does your vehicle qualify? Crossing the legal threshold.
So how do we cross that threshold from just an annoying car to an actual bona fide lemon? Well, not every single glitch counts. The law focuses exclusively on what they call substantial defects, meaning problems that significantly impair the safety, the use, or the value of the car. We're talking about major stuff: recurring engine stalling, the transmission slipping, brake failures, or those persistent electrical nightmares. A minor cosmetic scratch, or maybe a tiny rattle in the dashboard? Yeah, while super annoying, a squeaky cup holder generally isn't going to qualify you for a lemon law buyback.
Now, if you do have a substantial defect, then under the Tanner Consumer Protection Act, which operates right inside that Beverly framework we just talked about, this right here is your magic number, 18. We're talking about the first 18 months of delivery to you or 18,000 miles on the odometer, whichever happens to come first. This specific time and mileage window is absolutely critical for establishing your legal leverage.
Because if you hit any of these specific thresholds within that 18-month or 18,000-mile window, it creates what's called a legal presumption in your favor. Basically, the court presumes your car is a lemon from the get-go, which is a massive advantage for you. You trigger this presumption if the manufacturer makes 4 or more attempts to fix the exact same substantial defect, or just 2 attempts if the defect is deadly, like it could cause death or serious injury, or simply if the car sits out of service for 30 or more cumulative days.
All right, let's jump to Section 3, the Civil Code explained, your legal arsenal broken down. Let's take a second to translate some of that intimidating legalese into real-world impact. These 3 sections of the California Civil Code basically form your legal toolkit. First up, Section 1793.2. This outlines exactly what the manufacturer must do. They have to make the vehicle conform to the warranty, replace it, or refund it. Next, Section 1793.22. That's the Tanner Act we just discussed, and it legally defines what a reasonable number of repair attempts actually looks like. And finally, Section 1794. This is where it gets really compelling for us consumers, because it allows for the recovery of damages and even your attorney's fees.
In fact, Section 1794 acts as a totally powerful penalty multiplier. Listen to this. If a manufacturer just willfully ignores you, gives you the runaround, and clearly violates the act, a court can actually hit them with civil penalties up to twice your actual damages. That's on top of your refund or replacement. It's a massive deterrent, entirely designed to stop big automakers from simply stonewalling everyday consumers who are stuck with broken cars.
Which brings us to Section 4, calculating your lemon refund, making the consumer whole. So what is the actual reward if you push forward and win your case? Well, the core goal of the law isn't to penalize you just because your car's value dropped due to it being a lemon. The goal is to make you whole. You get back the full purchase price or lease payments. And yes, that includes your down payment. You get back your sales tax, registration fees, finance charges, and even incidental expenses, like towing and rental cars. The only thing that gets deducted from this total refund is one very specific item, the statutory mileage offset.
And honestly, this is where the law proves to be incredibly fair to consumers. The manufacturer can't just arbitrarily reduce your refund based on whatever your current mileage is. No, the mileage offset strictly reflects only the miles you drove before the car first broke down and required repair for that specific defect. It uses a very strict statutory formula, which completely ensures you aren't financially punished for all those miles you racked up just driving back and forth to the dealership trying to get the thing fixed.
Finally, let's look at Section 5, the timeline and process, navigating the battle plan.
Now let's map out the exact steps and deadlines you're going to face under the current rules. You usually start with weeks or maybe even months of just letting them try to repair the car while you strictly document absolutely everything. Then, under those new 2025 procedural reforms we mentioned, you hit day 1 by submitting a pre-suit written notice. The manufacturer then gets 30 days to respond to that notice, and if they've opted into the new system and things end up escalating to litigation, you generally hit a mandatory mediation within 150 days of their formal response.
So before you go blazing in seeking those massive civil penalties under the new system, you really must follow these specific steps. Step 1, have flawless documentation of all those repair attempts. Step 2, provide written notice that includes your VIN, a very thorough description of the defect, and the entire repair history. And step 3, you got to give them that 30-day window to step up and either repair, replace, or repurchase the vehicle.
Now, I know what you might be thinking. Full litigation and heading into a courtroom trial sounds awful. It can drag on for a year or even longer. But there is some excellent news here. Most lemon law cases actually resolve successfully through a settlement way before a trial ever even happens. Once you present an airtight case with thoroughly documented repair attempts that clearly cross that legal threshold, manufacturers are often highly motivated to settle within several months rather than risking a messy trial.
But, and this is a big but, you have to be vigilant. This entire process is strictly governed by a ticking clock. Depending on your specific claim, you generally have to file within 1 year after the express warranty completely expires, and absolutely no later than 6 years after the vehicle's original delivery date. Missing these strict time limits, it can permanently lock you out of pursuing your claim, literally leaving you totally stuck with a defective vehicle. No one wants that.
As the legal experts put it perfectly, your ultimate leverage against these massive automotive corporations relies entirely on your prompt action. The law provides incredible protections, absolutely ensuring you don't get stuck paying off a car that just doesn't work. But it requires you to be an active, highly organized participant in the process. You can't just sit back.
So you now understand the immense